Hi, everyone. The Authors Guild is happy to have you here today for a fair use Q&A with our CEO, Mary Rasenberger, and our Director of Policy and Advocacy, Mayor Kazi. Last month, they did a copyright Q&A and answered general questions about copyright, and it was clear that everyone wanted to talk about fair use more in depth, so here we are. And you can find that copyright Q&A on the Authors Guild website or YouTube. After receiving your questions about fair use, Mary and Umair prepared a presentation to cover the key points and explain the doctrine used by the courts to determine fair use. They're going to explain everything you need to know, and you can add more questions in the Q&A box below, and we'll address those after the presentation. For closed captions, please look for the button that says live transcript here in Zoom. And with that, I'll turn it over to Umair Kazi, Director of Policy and Advocacy at the Authors Guild, studied law at the University of Iowa and creative writing at Columbia University, and Mary Rasenberger, CEO of the Authors Guild. Thanks. I'll turn it over now.
Thank you, Johnny, and good afternoon or good morning, everyone, depending on where you are. Thanks for joining us this afternoon. So as Johnny said, we're going to focus on fair use today. We did get some questions ahead of time that related to more general copyright, and I would ask you to look at our last webinar, which was on basic copyright law for those issues. And in particular, we're going to focus on fair use vis-a-vis permissions for use in your own work as authors, since most of the questions we got, in fact, I think pretty much all of them, if they were related to fair use, were almost all of them were about permissions. So this is where you're using somebody else's work or quotations, a photo, an image, something from another work in your work. And you've decided that it's in copyright, it's not public domain. There's not a Creative Commons license or other indication that the use is available freely without permission. So you're looking at whether it's fair use or whether you have to go and obtain permission. So I'm going to have to repeat what I said last time. We cannot give specific legal advice in this format, but if you are a member, you should be aware that you can submit a legal inquiry, and at the end, I'll give you the link for that. You can always contact us through staff@authorsguild.org. We do provide legal advice on issues related to media and publishing law to our members. We also review contracts and provide other legal services. If you're not a member of the Authors Guild and you want legal advice from us, you can join for only $135 a year, and you do get a lot of the way in free legal services. It's a real deal, plus a lot of information, and online community, access to insurances, and a lot more. So I also cannot give definitive answers to many of the general questions that were submitted ahead of time, because fair use is all in the details. It's a very fact-specific inquiry. And as you'll see as we go through this. There are no bright line rules. I'm sorry to say we had a lot of questions about, can I use 3 lines from a poem? Can I use, a minute from a video? There's no bright line rules, I'm sorry to say, which is one of the problems with fair use. So just bear with us. I know it might feel frustrating at times not to get clear, easy answers, but that's why we're going to walk you through some cases just so you can see how courts have dealt with this, with the various specific scenarios. Umair is going to be, Umair is our Director of Policy and Advocacy, as Johnny said. He's going to be interrupting me from time to time to clarify if need be. He's also watching the Q&A, which I am not going to be doing. I'm going to rely on Umair to do that. And so if something isn't clear to you that you want me to respond to right away, Umair will flag me, and he's also going to try to keep me on time. So we have plenty of time at the end for questions from you. questions that aren't related to what I'm talking about at that specific moment for clarification, we are going to wait till the end to answer them, the end of our presentation. So let me share my screen now. Fair use, just to start from the very basics, it is an exemption from copyright infringement liability for using a work without permission. It was a judicially created doctrine until the 1976 Act, when it was added to the Copyright Act as Section 107. And Congress basically took the factors that courts had considered and put it into the statute. And I have to apologize. I have a dog behind me with a squeaky toy, and I don't know that's coming through. Somebody left a dog on my doorstep last night. He, I guess, abandoned anyway. So in addition to keep me up all night, he's behind me with a lot of squeaky toys. So I apologize for that. So to get back to fair use, Section 107 gives some examples of what fair uses are. It says for purposes such as criticism, comment, news reporting, teaching, scholarship, or research. Okay, these are traditional fair uses. And as you'll see, fair use has expanded quite a bit since 1976. But these are kind of the original traditional uses. So it is a balancing test. Just so you're aware, there's 4 factors. And in these 4 factors, you have to consider. So it is a balancing test. And it's when any use has to be considered in context. And that's why there are no definitive guidelines or firm rules. You know, there are questions like, are you competing with the original work? Are you commenting on the original work that you're taking? Are you taking more than you need to illuminate your point? Are you using it for the original aesthetic or to save time, or are you actually commenting on it? Okay, and all of these will become apparent as we go through this. So the 4 factors in the Act are, you know, you look at the purpose and character of the use, the secondary use. Is it commercial or is it nonprofit? And I'll go through each factor in a little more detail in a second, one by one. The nature of the work and the amount and the substantiality of what you're taking, and then also the effect on the market. So courts will go through all 4 of these factors. Another thing to be aware of is that it's case by case. So that's why it says in determining whether the use made of a work in a particular case is fair. Okay, you have to look at each case on its own facts. So the purpose and character of the use, as I said, it includes whether it's commercial or not-for-profit and educational, favoring the nonprofit educational uses. The commercial use is not necessarily infringement, it is just a factor. Now, in the early 90s, the Supreme Court added a new sub-factor to this factor, and that is whether the use is transformative. And one would say they were just summing up what prior courts had been talking about, you know, that transformative use was always in the factor, but they actually articulated it. And this has, ever since, is what happens a lot with Supreme Court cases, it really taken over the fair use analysis. As I said, it came from a Supreme Court case, Campbell v. Epigraphs in '94. And the test is whether the new use adds something new with a further purpose or a different character, altering the original with new expression, meaning, or message. Okay. So let me just mention what this case was about and why the Supreme Court adopted this standard. The case was Campbell v. Epigraphs. So Roy Orbison, many of you may remember the song "Oh Pretty Woman," And Two Live Crew had created a rap version that was, it's something like Big Fat Hairy Woman. You know, it was totally making fun of the original song and its, you know, kind of sentimentality. And the court said, the lower court had said that Two Live Crew's use was commercial. They took too much. It was not fair use. The Supreme Court said, well, no, this is a parody. To create a parody, you have to take a good amount of the original work. And the question here in the first factor is really what, you know, what did the secondary use, the Two Live Crew's use, do to the original? Did it add something new with a further purpose or different character? Asking, did it supplant the original or add something new? Different character, altering the first with new expression, meaning, or message. Now I know this seems like a lot of words, and courts have ever since been parsing out exactly what this means. And in fact, we just submitted a brief to the Supreme Court in the Warhol, the Goldsmith case, on this precise language and how courts should interpret it, because it hasn't been always interpreted consistently. But the court basically says, you know, parody has an obvious claim to transformative value because it sheds light on the earlier work. It criticizes the earlier work and creates a new one. And the court also said, I should add, that the more transformative the secondary use is under the first factor, the less weight is given to the remaining three factors. And that is something that you will see in each of the cases that we, the post-Campbell cases that we go through. In fact, very few cases where courts have found transformative use have they not found fair use. Transformative use under this analysis that courts have taken from Campbell v. Epigraphs almost always ends up in a finding of fair use, even though that shouldn't necessarily be the case. So the second factor, Ron, is the nature of the copyrighted work. That's the work that you're using. If it's factual, news, more likely to be fair use. If it's creative, fiction, more likely not to be fair use. Courts also look at whether it's published or unpublished, unpublished being less likely to be fair use, since that right of first publication is a right that should adhere to the author. Now, but it's not determinative. I should say that under the post-Campbell analysis, this factor is never determinative, in fact, and often courts will say it doesn't even really matter, particularly if the use is transformative. The third factor is the amount, how much was taken, but it's not just percentage-wise how much was taken. Courts will also look at the quantitative amount taken. Did you take the heart of the work? Did you take the core of it? Did you take the chorus from a song? And this Harper and Row case, also a Supreme Court case from 1985, this is pre-Campbell, looked at just that. So Gerald Ford's autobiography, A Time to Heal, was not yet published. And the publisher, Harper and Row, had sold the first serial to Time magazine. Well, The Nation got a copy of the book and scooped Time. And they published just these few paragraphs from the book. But it was where Ford explains why he pardoned Nixon. And the court said, so short, you know, this whole book, relatively short quote from it. But the court said, this is not fair use. You took the heart of the book, the heart of the work, and furthermore, the nation's use, it supplanted the copyright holders' commercially valuable write a first publication. So the takeaway from there is don't take the heart of a work, even if you're only taking a small amount. So the fourth factor is, I think, and should be really the most important factor, and that is whether you're supplanting the market for the work, or you are in any way affecting the market or value of the work. And the test under this factor, according to the Campbell case, is the effect upon the potential market, not just the market, for the value, if the use is unrestricted and widespread. And that is really important. That's something that I think it's always important to remind courts of, because they often go into sort of damages analysis on this, you know, how much harm has the plaintiff, the copyright owner actually suffered. That's not what the analysis should be here. It should be, if everyone's doing this, what is going to be the impact on the value of the work? And that's, of course, important, because once there's a decision that says it's fair use, everyone's going to do it. And the other thing to note is that this includes licensing markets. So just a couple of things to remember before we look at the cases. Really an easy yes or no, with some exceptions. Again, no hard and fast rules, no 3 lines are okay, 3 minutes. It just depends on the context. How long is the work? How much are you taking? How much are you commenting on it? Are you transforming it in any way? And are you usurping a licensing market or other market? Also, not every factor is given equal weight. Again, depends. Also, as I mentioned, fair use is getting more expansive, particularly since the Campbell case. And the other thing, another takeaway, is that it's because things aren't so black and white in fair use law that people can bring lawsuits, even if you're pretty sure you'd win in a lawsuit. You do have to consider whether or not someone might bring a lawsuit, because lawsuits are expensive to defend. And that's why your publishers may err on the side of caution. We do see publishers still asking for permission for very simple, very short quotations, sometimes even. And that's because, you know, they've had cease and desist letters probably over these kind of uses. And even though fair use is expanding, they don't want to get sued. And you don't want to get sued either, I'm sure. So I'm starting with the cases. I'm going to go through them pretty quickly, because it's just to give you a sense of how the courts come out in these cases. So I'm starting with 1987. This is Umair. I should stop. Do we have anybody with urgent questions yet?
I think that you can probably cover some of the cases and then go to the questions, because I think you answered a lot. The discussion will answer some of the questions.
Okay, cool.
Yeah.
So this is a case where Hamilton wanted to do an authorized biography of Salinger. Salinger said no. So Hamilton found some unpublished letters in an academic archives, and he took those letters and paraphrased large portions of them. Of course, did not get permission. And the court said this was not fair use. The court said took way too much. And in fact, the letters were the backbone of the biography. Rather than using the letters as commentary or to illustrate, illuminate, the letters, you know, really were the structure of the book. And the court said they were more a means of capitalizing on the interest in Salinger than providing the critical study. So not fair use. Okay, here, another book, just 4 years later, Richard Wright biography. The author, Margaret Walker, quoted from 6 unpublished letters and 10 unpublished journal entries, but altogether only used 1% of the letters. Wright's widow sued, and the court said this is fair use. Okay, the use was informational. The quotes were used in context of the biography. They were used to illustrate. The narrative did not rely on the letters, but rather the quotations were used to support the narrative. So this is fair use. Now I'm going to talk about a couple cases involving books, sequels, presumed sequels. So I assume everybody knows the book Gone with the Wind. Sometimes surprised when younger people don't, because it's, you know, I think most people agree it has a lot of racist elements in it, so it's not a book that's widely read anymore. But back in the late 90s, when Alice Randall wrote The Wind Done Gone, I don't think people were as critical or thinking as much that way, but she did. So she took Gone with the Wind and actually created a really interesting, I guess you might call it sequel, or although it's taken at the same time. So she tells the story at the same time period of Gone with the Wind, but from the perspective of one of Scarlett O'Hara's slaves, her half sister. The court said, and didn't the story, the story isn't all the same, but it's the Gone with the Wind story is the background. There are a lot of the same characters. And the court said it was fair use. It said The Wind Done Gone was a parody. It commented on and criticized the original work. It criticized Gone with the Wind's depiction of slavery and race relations in the antebellum South, where it romanticized the antebellum South, and you know that from the Black's perspective, life on the plantation was not as rosy as was portrayed in Gone with the Wind. So the court said, yes, this is commercial. It's a commercial use, but it's transformative. And it's a transformative parody. It also concluded that there would be no effect on the market for Gone with the Wind. Now, not that 8 years later, we have another case. The SunTrust v. Halfland Mifflin, the Gone with the Wind case was in the 11th Circuit. Salinger v. Colty was in the 2nd Circuit. Here, the court said, let me explain what this is. 60 years later, it was written by a Swedish author, Frederick Colting, and it takes the character of Holden Caulfield, calls him Mr. C. 60 years later, the character is basically the same, certainly modeled on the 20-something or younger, I forget how old Holden Caulfield was, a young man, and claimed it was not a sequel, but a parody after he was sued by Salinger and his publisher. And the court didn't buy it. The court said, you took too much from the book. This book would undermine the market for sequels, and that just aging the character and put him in the present day did not add something new. It did not transform the work, particularly since the character's personality remained intact and came from the original work. And he said it wasn't a commentary. The court said it wasn't a commentary on the original work. So not fair use here. Now, this is a case that you might have heard of around the same time, also in the 2nd Circuit. The 2nd Circuit is the New York region beyond, where a lot of copyright cases are in the 2nd Circuit because a lot of the industries are there, which is California entertainment, where much of the entertainment industry is based. In this case, a fan of Harry Potter created a lexicon of the Harry Potter books, and he quoted extensively from the book, from the books. And so Rowling's publisher sued, and the court said that even though this is slightly transformative because he was creating the lexicon, it was not fair use because he just quoted too much from the books. And there wasn't enough commentary, there wasn't enough analysis. And Rowling agreed. She issued a statement saying that the proposed book took an enormous amount of my work, added no original commentary, and said, many books have been published which do offer original insights into the world of Harry Potter, but the lexicon is just not one of them. And the court obviously agreed. But interestingly, the defendant did issue a new version with less quotation, more commentary, and Rowling blessed it. This is a case of, there were a number of questions about using images in your work. And I know this comes up a lot. This is a coffee table book about the Grateful Dead. And you can see there are a lot of images in it. Among the images they used were posters that were made for the concerts for the Grateful Dead, which were often really, really fun and cool. So here you have an image of one of the posters, and it's in the book, but you can see they're in much smaller size. Maybe it looks like, maybe kind of 2 inches or something like that. Now, what's interesting is there is a licensing market for artwork to be used in books and in other works, but the court here said that this was fair use. So, I think this is, for those of you who want to incorporate images, this is a really good case to rely on. If you're adding commentary, you're not just using the pictures because you like them, they're pretty, but they pertain to what you're writing about. If you're commenting on them, criticizing them, or they in some way, illuminate your story, and you reduce the images in size. Again, I'm not sure your publishers would rely on this, and this is a Second Circuit case, so it's not necessarily the law outside of the Second Circuit. But and when I will say, when this decision came down, people were quite surprised by it because they thought, well, there is a licensing market for this kind of use. But the court said it was this use was transformally different than the original purpose. Said the original purpose was advertising a concert. I would say it was also aesthetic. But the court concluded it did not exploit the expressive value of the images. It also said that under the fourth factor, it didn't harm the market for the works themselves because they were reduced in size. But again, I would say, but what about the harm to licensing markets? But it's the law in the Second Circuit. So here is a case. Somebody asked about summaries, and there were a couple other related questions. And I think this case is very on point for those. This is Quotation, same guy who wrote 60 Years Later. He and his wife created a series of children's versions of classic adult books. You can see here Old Man and the Sea, Kerouac's On the Road, Breakfast at Tiffany's, 2001 Space Odyssey. They did a whole series of these books. And they basically just abbreviated the books, took out adult language, adult themes, and added a few pages of commentary at the end with a little quiz. The court said, well, this is not transformative. They're just shortening the novels, removing adult themes, adding a few pages of analysis and quiz questions, but the court said they did that just to manufacture a fair use defense. And that it's very different than using a work in a book, a description of it or a portion of it, and then criticizing it and commenting on it. And it said, I like this quote, that fair use is not a jacket to be worn over an otherwise infringing outfit. In other words, the court will look through attempts to just dress up an infringing use as a fair use. And again, the court said they took nearly the entire novels, they took too much. The court did look at the second factor here and said these are creative works. And in the fourth factor said there is an established market for children's versions of adult novels, and the fact that PRH wasn't already in this market didn't really matter. Okay, so I'm going to talk about a couple. There were a bunch of questions about song lyrics. And song lyrics are a little different, as a lot of the questions seem to acknowledge. And that's because there is a very active licensing market for music, for both lyrics and for music and for sampling. So this case was the Anthony Barre, who went by Messi Maya. He died shortly, well, before the case, actually. He was a YouTube star comedian. And Carter is Beyonce. So in Beyonce's song Formation, which was on Lemonade, she has 10-second audio from one of Messi Maya's videos, saying what happened at the New Orleans. Oh yeah, baby, I like that. And bitch, I'm back by popular demand. So those are, it's, you know, his voice interspersed in the album. And the court looked at this. So I should say this was on a motion to dismiss. So Beyonce's lawyers filed a motion saying this is so clearly fair use. It's not infringement. You should dismiss this. And the court said, no, we're not going to dismiss this because we actually don't think it's fair use. Because, and certainly this needs to go it needs a full hearing on whether it's fair use. But on our preliminary analysis, they said there's nothing new added. This is not transformative. You just took the clips unmodified. It's commercial. The clips were creative. They were published. And that even though it was a small amount that was taken, again, we'll go back to the Harper and Row Nation case, it was qualitatively significant, you know, took kind of the heart of it. And then, of course, they noticed there is this vibrant sampling licensing market for YouTube videos. And the defendants here had recognized the necessity of obtaining the license. Trust, in this case, this is Oscar Smith's estate via Cash Money Records. Jimmy Smith was a jazz artist. He had a rap, a talking part in one of his recorded songs saying jazz is the only real music that's going to last. All that other bullshit is here today and gone tomorrow. And a Drake song sampled 35 seconds of it, changing the words a little bit, deleting the beginning so that it said only real music. It took the audio, the actual audio and the words. Only real music is going to last. All that other bullshit is here today and gone tomorrow. And Cash Money had obtained a license for the recording, but not the composition. And I should stop here and just explain that there are, in any recorded piece of music, there are two copyrights. One is in the sound recording, which is the recording of the actual performance, what the recording artists are, you know, playing. And that's owned by record companies generally. There's also a copyright in the underlying musical composition. And the way I like to think about that, it's what you could, you know, you could write in sheet music or in lyrics, write down. So Cash Money had gotten a license for the recording, but not for the composition, meaning the words in this case. So the court looked at this and said, well, this is transformative because even just by taking, you know, jazz out of the beginning of that and saying only real music is going to last, they transformed it. It has a different purpose or message. So you can see how courts can take that language from Campbell and, you know, you can almost fit any use into it, honestly. And they also said the amount taken was reasonable in proportion to the needs of the intended use. And on the fourth factor said these are different markets. No evidence was provided of a usurp market. So here they said it was fair use. So now I'm sure I have totally confused you because these cases are kind of similar, but the courts came out differently. And again, it's just part of, there's not a ton of clarity here, particularly at the district court level. The courts take transformative use and they kind of, in some cases you feel like they made a decision and then they made the factors kind of work around their decision. And, ultimately that is kind of what fair use is about. It's whether use is fair, ultimately. And that's where the case law started, is just, and how do you analyze whether it's fair? How do you analyze whether there should be a use without permission? And, I think in particular, several of you asked about, well, what if I asked permission and didn't get it? That actually can weigh in your favor if it's a parody or a criticism, because those are the kind of uses that courts actually, and the copyright law wants to foster. We don't want copyright being used in a way that suppresses new expression. What's going on here? Now I seem to be going backwards. Okay. So I'm just going to do a couple more cases and then we'll get to Q&A. They're just a couple Dr. Seuss cases. I can do these pretty quickly. They're just kind of fun. How the Grinch Stole Christmas, Dr. Seuss book, was turned into a theatrical production, a parody called Whose Holiday. And here the court said this is a parody, protected, fair use. And concluded that the producers, Lombardo, hadn't taken too much. It was sort of making fun of the seriousness of Christmas, and of the Dr. Seuss book. So, but then, in another case, you've got the Dr. Seuss book, The Places You'll Go. And here, Comics Mix, the defendant, created a mashup with Star Trek and took the book, changed the text quite a bit, though kept the same kind of rhyming and cadence, but used a great deal of the images. So you even see on the cover, the places you'll boldly go instead of the places you'll go. And I don't know if you can see this, but you can see how copied the bottom ones are the copied version, I believe. Yeah, here in the Star Trek, obviously the one on the right is the Star Trek version. Same here, one on the right is the Star Trek version. So really, really close, the images, and the text, a lot was taken idea-wise in the text too. So the court here said this was not a fair use, just too much was taken. Comics Mix said, oh, but it's a parody. Parodies are protected, and the court didn't buy it. This was the Ninth Circuit. They said, no, this is not a parody. You took way too much. It's just a mashup with Star Trek. You should have gotten permission. And in fact, they'd asked for permission and it was denied here. And then they also concluded that the market was usurped because these are both, so the Dr. Seuss book, Oh, the Places You'll Go, I hadn't known this, but actually this was the year my daughter graduated from college, so I bought it for her. It's actually a graduation present that people give a lot, Oh, the Places You'll Go. And apparently the Oh, the Places You Boldly Go, the Star Trek version, was targeting that same market. So court says no fair use. This, I'm just going to, a bunch of you asked about using images that you find on websites online. Don't do it. unless they come with, look at the terms of use, if they come with a Creative Commons license or otherwise clearly say, or on some site where it's like, these are free to use, or otherwise clearly states this is free to use, and you know it's on the original site, it's not a copy somebody else put on their site. Otherwise, get permission. So in this case, the photo on the left was the original photo. It was used in marketing materials. On the right, you can see they just took a sliver in the middle, the main section of the photo. Court said, this went up to the Fourth Circuit, said not fair use. So some takeaways, just a short quote from a much larger work is usually going to be fair use, especially if you're using it to explain, teach, or comment on the original work. Again, if the use is normally licensed, like a sequel, spin-off, sampling of music, then it's likely not fair use. There's a not missing there, excuse me. But there are exceptions like parody or criticism, where the copyright owner is unlikely to give permission. Also, don't take more than you need to make your point. Take as much as you need, but no more. And one thing to keep in mind, if you ever think you're using somebody else's work to save you labor from writing something yourself, or if you're using it for its original aesthetic value, because you think it's nice and it'll entertain your readers, rather than to illuminate a point you're making or to comment on it, it's likely not fair use. So that's a question you can just honestly tell yourself. And because courts often can see through that, if you've seen through some of these examples. So for instance, if you're using, you can use a couple lines from a song if you're using it in context, right? So if you have a character singing a song from the 80s, like you have a novel set in the 80s and it's something somebody might be singing, that's okay, but keep it short and only as much as necessary to show that your character, what kind of character it is, that, what the ambience is, whatever. Or if you're using a couple stanzas from a poem in a book about the poet, or you're commenting on if you're commenting on a poem and analyzing the whole poem, you can actually use the whole poem, but there's gotta be a purpose for the use, okay? Only take what you need to make your point. For images, if you're using an entire image, make the reproduction small or low resolution and make sure you're commenting on it, giving it context. You're not just using it for its original purpose. And also don't take the heart of a work, even if it's a small amount, like I said, the chorus of a song, unless it's a parody and you need it to conjure up the original. For quotations, there's no magic number. Taking a few sentences from a book or letters here and there, like in the right case, that's going to be fair use. That's like your traditional fair use. But do you use quotation marks in cite where appropriate? For scholarly works, we did get a couple questions about that. Just follow academic citation rules, and plagiarism rules. Even if you are plagiarizing, meaning you're not, taking the exact words, but you're basically taking somebody else's work and rewriting it using different words, that's still going to be infringement. Technically, people asked about different rules for different kind of works. Technically, the rules are the same no matter what kind of work you're using. But remember, the factors are going to come out differently on different types of work. So as I mentioned, using music, lyrics, sound recordings, where there's a very, very robust licensing market, or sampling, you've got to factor that in the fourth factor. Epigraphs, a lot of people ask about that. Yeah, you can use quotations as epigraphs, but it's not going to be transformative under factor 1. So make sure if you use a quotation as an epigraph that it has a context, that there's a reason for your using it. that you're pointing back to it somehow. And you're not just using it because you like it for its original aesthetic purpose. People asked about other countries. Fair use is a US law. No other countries have fair use per se. They have very specific exceptions, which we do too, but there's in some cases cover some of what our fair use does. But so you do when you're using a work in your book or other work that you're creating, and it's going to be published abroad, you do have to get advice on the laws in those other countries and whether there's an exception that applies. So I'm just going to quickly go through some of the things that people asked about in the pre-submitted questions. Book summaries. I like this question because this is one of my my pet peeves. There are a bunch of summaries I'm sure you've all noticed on Amazon. Some of them seem to be created by computers because they're so bad. But if they're just summaries, going back to that Kinderbooks case, that's not fair use. That's going to be infringing. If they have a lot of commentary, and some of them do, then it might be fair use. And that's why Amazon keeps a lot of them on their site. We've had conversations with Amazon about this. Just because something's a summary, it is not fair use. Whereas something like the Cliff Notes, where there's a lot of analysis that, you know, might be fair use. Translations, you cannot make a translation under fair use. That's just not a fair use. That's taking too much. If there's a market, you know, translators need to, you know, translations need to be licensed. When you don't take online, people ask about quoting from online forums or blogs. The issue there, the same analysis applies from a fair use perspective, but you have to check the terms of service. There may be privacy issues. There may be rules in the terms of service against using anything in the forum or the blog in another context in public way. I know in our online forum, we have a very clear rule that things that are in the forum stay in the forum. Videos, films, you can use clips, you can use stills, but all those rules apply. Use context. Don't take more than you have to. Use it in a transformative way. Where the author's dead doesn't matter, does not affect the analysis. You saw their cases brought by estates, and if anything, estates tend to be more litigious than the authors themselves are. Parody we spoke about. Parody is definitely a protected fair use if it's really a parody, but it's really got to be a parody making fun of the original work. If you got a bunch of questions about if you ask permission and you're told no. Okay, this is not one of the 4 factors, but courts will look at it. And for one, if it's a parody or a critique, the court will say, well, of course they said no, you know, or you didn't ask because they would have said no. And that's why we have fair use. You know, on the other hand, you know, the court will say, well, you asked permission and they said no. You know, if it's not a parody or it's not commentary or clearly transformative, it could weigh against you. But if it's transformative, commentary, parody, shouldn't matter. Somebody asked about speeches and said, especially made by government officials. You didn't say whether it was federal government or state, but just so everyone's aware, federal government, anything created by a federal government official is part of their duties is in the public domain. So anything the president says, any member of Congress, anything officially from the federal government, free for anybody to use in any way. Otherwise, speeches are protected by copyright and same fair use analysis applies. Taking photos from websites I mentioned, because don't do it without checking terms of use. We do a lot of advocacy work with photography associations, and it is so hard to be, it's, you know, as bad or worse than trying to be a writer today. because everybody just steals your work from online, and it's very hard to actually monetize it. So don't do that. They because of the problems they've encountered with theft of their work online, photographers are being more litigious, and there are a couple different attorneys out there who just sort of do mass amounts of claims for use of photographs taken online. Somebody asked, we're kind of running out of time and I want to get to questions, but AI created works based on copy. If you're using copyrighted works to create AI created works, that should not be fair use if you're creating competing works. And I just want to say that our bulletin issue that's coming out, I think this week, talks about that quite a bit. So let's, Umair, let's move on to some of the questions. And I'll just note on this is my last page that if you're unsure about something, you can get media liability insurance, and the Authors Guild provides, can provide you with it. Umair, I'm going to turn it over to you.
Yeah, thanks, Mary. So I think there were a few questions about fan fiction. I don't know if you want to just generally speak to whether or not fan fiction, based on the precedents that you've discussed, would likely be fair use or not, or it's kind of goes into derivative.
Yeah, okay, so it might be, yeah. So derivative works can be fair use. So fan fictions are derivative works by definition, right? You're taking an existing work and sort of creating a sequel kind of thing, a little bit like 60 Years Later, that could be like fan fiction. But one thing about fan fiction is that if it's for personal use, it's not commercial, the courts will look at that in the fourth factor. Okay, so the fourth factor is going to come out a little differently than a published work. The lexicon also, the Harry Potter lexicon was kind of a fan fiction thing. I would say a lot of fan fiction is not fair use unless courts are persuaded. Well, actually, that's not really true, because it could be completely transformative. But under the fourth factor, it's going to be, you're cutting into well-recognized licensing markets unless it's not commercial. So it kind of depends. Now, the other thing to think about though with fan fiction is that the fact is it is tolerated. Most writers don't go after fan fiction until it becomes commercial and competes with their works. So they allow fan fiction, their publishers allow fan fiction because it's, you want your fans to be having fun with your work. And if anything, it helps promote your own work. But if you are a fan fiction writer and then, want to start selling your books to publishers, that's going to be a problem.
Okay, so this is an interesting question from John Deegan Canada about the whether or not there is a fair use or other exception for classroom use. I'll just read. I see the teaching category is there under fair use. Can you break that out a little bit? In Canada, incidental copying for classroom use is allowed, but industrial scale copying to create course materials is not. Is that the same in the US?
John, I'll get on the phone with you another time because this is a lot. This could take me an hour to explain. But there is some teaching allowed under fair use. It's one of the original fair use copies for classroom use. We've always had that, that as an important fair use exception. But in the fair use analysis, the fourth factor comes heavily into play, because there are obviously for educational materials, if you're making free uses of educational materials in educational settings, you're usurping the market, and it's not transformative. It's planting the market. So generally speaking, use of educational materials is in the classroom is not going to be fair use. But we have separate exceptions. So in addition to fair use, US law has what is it? It's like sections 108 to I think it's 122 now, takes up over 100 pages, you know, and here's the statute. It's like almost, yeah, the first half of this book is all exceptions. Yeah, these are all exceptions, specific exceptions out of this book, in addition to fair use. And one of them is section 110, which includes some specific exceptions for classroom use. And I can send that to you.
Okay. So this one, I think, kind of goes to your discussion of the Catcher in the Rye v. Colton case. If I want to write the next Charlie Chan novel, do I have to wait till all 6 books are in the public domain? 2 are now there, with a 3rd coming out in January 2023, or can I continue the storylines from the first 3 as long as I don't touch the last 3 stories? It's an interesting question. So
it's such a good question. Oh my God. So this, because it's, you know, the characters, I would say yes, but there was a case brought by the copyright owners of Sherlock Holmes. Most of the Sherlock Holmes books at the time were out of copyright, but I think there was like 1 still in copyright, and the case was saying you can't use the characters because they're separately protected, even though the new work wasn't using the uncopyrighted Sherlock Holmes work in any way. And you know what? While we're still on the line, I am so embarrassed. I don't remember how that case came out. I think the court said characters can be protected, but I think the Sherlock Holmes estate, not the Sherlock Holmes estate, the author Conan Doyle, lost.
I think that's what happened. I think the state
prevailed. Yeah, I'm going to email you. Unless if anybody else on the line knows, put that in the Q&A.
So this one I think that a lot of our attendees will benefit from. Who is liable to be sued for fair use infringements, the author or the publisher? So if it's
the publisher, the publisher will in the first instance. They might include the author too, but the publisher is going to get sued because they're the ones publishing the book. But you have in your agreement, in every, I don't know if I don't think I've ever seen a publishing agreement that didn't have reps and warranties that said, I, the author, represent and warrant that my book does not infringe the copyright of anyone else. And then there's an indemnity on that saying, if it turns out my reps and warranties aren't true, I indemnify the publisher. Now, the good news is that publishers have media liability insurance. That will pick up that they're not going to lay all the costs on you, but they might ask you to pay the deductible, which can be quite high. It can be a couple $100,000. And that's why we do say get media liability insurance if you feel like there's a risk of being sued, whether it's for copyright or like, defamation, right of privacy, that kind of thing.
Okay. So this one is a little interesting. If the nation had summarized the heart of the Gerald Ford's book instead of quoting it, would that be fair use?
That's interesting. That's, yeah. And of course, this was a pre-Campbell case, would it come out differently afterwards? I don't know. I mean, the real factor here was that the publisher, Harper Monroe, had an agreement with Time for first serial. And the book hadn't been published yet. And that the use directly interfered with Time's first serial rights. And they obviously dropped out and refused to pay for the first serial rights or publish it. So if it's paraphrased enough so that it's doing that, yeah, that could be deemed not a fair use. And that's a good question, because paraphrasing doesn't always get you around copyright infringement. It can. I mean, there are two ways to look at, infringement. You can take the actual expression, which is like the words, but the expression can be, it can also be the structure of the story, the characters. If you take somebody's book and basically rewrite it with different characters, different scenery, different characters, different names, and just change it up a little bit, and using different words, you could still infringe. Those are way harder cases to prove, but paraphrasing doesn't get you around infringement necessarily. And I'm sorry, I know this is frustrating for people because it's like so much, it depends. Yeah.
Yeah, it depends. I think we could probably do one last one that kind of touches the things that we have been discussing. Can I reimagine old cartoon characters in a commercial work, short story? The characters are transformative. In placing them in a modern situation, the story is a statement on aging. So I guess like the question is, would that kind of go into parody? Maybe you just want to reiterate like what the cases that do that.
So you're commenting on aging and not the original work. So courts have been very lenient on parodies of the original work. So the Two Live Crew case, the Roy Orbison song, they said that's a parody. You needed to take it. The musical based on the Grinch story, again, that was clearly a parody of Grinch. On the other hand, and that was always sort of the standard, that if you're criticizing, commenting on the original, it's okay. There was a case in the Second Circuit not that long ago where the artist Prince took a bunch of photographs that a photographer, Cairo, had taken in Jamaica, of Rastafari life, sort of serene Rastafari life. And he had them in a book, and Prince cut them out of the book and made collages out of them, or in some cases just put blue paint over them and went put a guitar on the guy, combined them in some cases with other images, and created this whole series using Caru's work. And he refused to say he was commenting on anything or had any message as part of his artistic, but whatever. He's like, I'm not commenting. I'm not criticizing. And the court said, you know what, that doesn't really matter. It's still transformative, because the viewer of your work will see that you've transformed it. So again, that's one of those cases where I'm sorry, but maybe not. You take too much, look at the Dr. Seuss Star Trek book. That I think everyone looked and was like, oh my God, that is not a fair use. Took way too much, was not a parody. So, and if you're, sort of commenting on aging, that's not a parodic use. So I would be extremely cautious with that, and this is not legal advice, that's just a hypothetical. But that's something I'd want to try to get permission for, at least get a lawyer to review it.
Okay, so I guess we'll just do one last one, since
Okay.
a couple of people echoed this. If you use a quote from someone's book, short 1 or 2 sentences, to support a narrative point you're making in a nonfiction book, is that fair use? Is that considered analysis or commentary?
That strikes me as sort of the typical fair use. Yeah.
That's what I thought. Yeah.
And I should say, if you're using like 2 lines from something, and where you really think it's a fair use, and your publisher says, you need to get permission. Well, ask them why, first of all. But if something is like a clear fair use and your publisher insists you get permission, if you're a member, again, come to us. If you're not a member, join and come to us. You know, we just you can submit a legal query and we'll help you out, because we can reach out to the publisher and try to figure out why they want you to pay for that when it's so clearly a fair use. It may be because there are certain copyright owners, and as I said, they tend to be estates who are very litigious. The Dr. Seuss estate, you know, the Sherlock Holmes estate, there are other estates, T.S. Eliot estate, where the publisher may have dealt with them before and it's just like, no, or some publishers just have really strict rules because they don't want to be in a lawsuit. But we can help you out with that.
I think that's it, Mary. I think we got all
Okay.
the big ones.
Okay, so, and if there are any other questions that we can help with, we can maybe provide them later. So thanks everyone for joining today, and I hope you learned something.